Okay, let's unpack this. Imagine a really dramatic scenario. Someone gets charged with serious crimes, goes to court, actually convinces a judge to grant them bail. They step back out, trusted, right?
Right, trusted by the system to follow the rules while waiting for their case.
But then, while they're out on that freedom, that court-granted trust, they get accused of committing brand new crimes, potentially even more serious ones. What on earth happens next? I mean, can they possibly get bail again?
Well, that incredibly tangled, high-stakes question, that's really at the heart of a legal fight that went all the way up to the highest criminal court in New South Wales.
This wasn't just, another day in court then.
No, not at all. It was actually a pivotal moment, a real test of the limits of Australia's bail laws. So welcome to our deep dive into Moukhallaletti v. Director of Public Prosecutions, NSW, NSW-CCA 314.
Moukhallaletti, got it.
Yeah, this case became a crucial test, really, for understanding how the system tries to balance things, an individual's liberty versus community safety, and crucially, the integrity of the justice system itself, especially when that initial trust seems to have been broken.
Okay, so our mission today is to take you right inside this legal drama. We want to introduce the key players, and not just the accused, Kristen Moukhallaletti, but the lawyers, the judges involved, the whole system in action.
And we'll trace the procedural steps. It's quite a journey, from the first charges, through the different court levels, right up to that final judgment in the Court of Criminal Appeal. We'll highlight the legal hurdles, the arguments, the strategies.
And importantly, we need to understand exactly how this specific case has actually shifted things, how it's changed the way similar situations are handled now in Australian legal practice. Think of this as, well, your essential guide to a really significant decision.
It's definitely a powerful story. It's about trust, it's about consequences, and it really gets into the challenging reality of applying these complex laws in, frankly, very highly charged situations.
Okay, let's set the scene then. Where does it all begin? It starts with Kristen Moukhallaletti facing an initial set of charges, right?
That's right. She was initially facing 3 specific charges. They all related to fabricating or falsifying evidence with the intent to mislead a judicial tribunal. These are under Section 317 of the Crimes Act.
So, attempting to mislead the court, essentially. Serious stuff.
Very serious. Each one carries a potential 10-year sentence. And all 3 charges allegedly stemmed from one specific incident back on the 16th of September 2015. This happened at the Metropolitan Reception and Remand Center, the MRRC, at Silverwater.
Okay, and there's some important background involving her husband, too, isn't there? This wasn't happening in a vacuum.
Absolutely not. It was deeply connected to a much bigger investigation. Her husband was facing, well, extremely serious charges himself, supplying large commercial quantities of methamphetamine, dealing with proceeds of crime, directing a criminal group, a major operation, allegedly.
And he eventually pleaded guilty.
Yes, he pleaded guilty later in September 2016 and was in custody. The Crown's case was that he had access to really substantial amounts of cash and assets. We're talking planes used internationally, suggesting a very sophisticated setup.
And crucially, he'd been on bail himself earlier with a specific condition.
That's key. He got bail back in April 2015, but under strict conditions, including one that specifically forbade him from contacting any co-accused except through their lawyers.
Right, so how does the alleged incident at the MRC, the prison visit, fit into this?
Well, this is where the first set of charges against Mrs. Moukhallaletti comes in. The Crown alleged that on that day in September 2015, she went to the MRC to visit one of her husband's co-offenders. This was a man who'd been locked up for about a year, and crucially, the Crown said she'd never visited him before.
And this visit was recorded?
Yes, it was captured on CCTV.
So what did the Crown claim happened during that visit?
The core allegation was that she asked the prisoner to do that statement, referring, allegedly, to a false statement about who owned drugs and firearms that had been seized, something her husband had apparently discussed with him before.
Okay, asking for a false statement.
That was the allegation. And then, according to the Crown, she immediately changed the subject and started talking about the prisoner's family. The Crown inferred this was an implied threat, pressure.
So the picture the Crown painted was an attempt to get false evidence to help her husband, possibly using intimidation.
That's exactly the Crown's case for those first 3 charges. And things developed after that visit. The prisoner was moved to a different jail. He didn't appear via video link at a hearing with the husband when he was expected to. And the very day after he failed to appear, Mrs. Moukhallaletti allegedly visited him again. This time, the Crown says, she expressed suspicion that he'd rolled, meaning cooperated with the police, and told him her husband wanted to give him money, but crucially, after the false statement was provided.
So the Crown saw this as a pattern, a concerted effort to obstruct justice.
That was their submission, yes. Seeking a false statement to benefit her husband.
Okay, so those are the initial charges. But, and this is really important, despite how serious they sound, when she was arrested for these back on 17th November 2015, the court did grant her bail.
It did. Conditional bail. And this is a critical starting point for the whole story. It shows that at that initial stage, the court looked at her circumstances, applied the bail tests that were relevant then, and decided the risks could be managed. She could be in the community under conditions while waiting for trial on these first charges.
So she was out on bail for these initial matters, which were heading toward the summary hearing in the local court early in 2017.
Correct. It signifies that initial grant of trust from the legal system.
But, as the hook suggested, that trust and her freedom turned out to be, well, precarious, because while she was out on that bail.
Exactly. This is where everything changes. The plot, you could say, thickens dramatically, and the legal landscape shifts completely. While she was on bail for those first alleged offenses, the authorities alleged she committed new offenses.
And these weren't minor things.
Oh, no. They were described as detailed, deliberate, and actually more severe than the first set. This dramatically raised the stakes for her and for the whole bail question.
Okay, so what were these new, very serious allegations?
Two main charges in the second set. First, another count of intentionally fabricating false evidence again, Section 317B of the Crimes Act allegedly committed between June and July 2016.
So, a similar type of offense to the first lot?
Yes, but then there was the second charge, dealing with proceeds of crime. This involved a substantial sum, $170,000, allegedly between July and September 2016. Now, this charge under Section 193B1 is strictly indictable.
Strictly indictable meaning?
Meaning it's too serious for the local court, it has to be dealt with in the district or Supreme Court, and it carries a maximum penalty of 20 years imprisonment. Very serious indeed.
Where did these new charges come from? What was the context?
They arose directly from that ongoing wider investigation into her husband's alleged financial activities and the assets of his supposed syndicate. The NSW Crime Commission was involved, getting restraining orders over properties linked to the couple. Investigators discovered that a property at Teresa Park had been sold. And then a man named Mr. Ryan Cooke, described as an associate of the husband, lodged a caveat over the property, basically, a legal claim on the title.
Mr. Ryan Cooke. He becomes important here.
He becomes absolutely central to the second set of allegations because, crucially, investigators found that $170,000 from the proceeds of that property sale was deposited into Mr. Cooke's bank account. And this happened on 8th July 2016.
And the significance of that date.
It was just before the Supreme Court made restraining orders over the couple's assets on the 13th of July. The timing looks suspicious.
So, Mr. Cooke, what was his story when the police got involved?
Well, police executed a search warrant at his home in August 2016. And according to the police evidence presented later, Mr. Cooke told them something quite startling. He claimed the husband only owed him about $35,000, maybe just $25,000, which meant, he alleged, that the $170,000 caveat he lodged was completely baseless, fraudulent even.
Wow. So he's saying the claim underpinning the $170,000 transfer was bogus.
That's what he told police. But then he made an even more critical allegation against Mrs. Moukhallaletti herself. He claimed she had coerced him, pressured him, into providing a false statutory declaration.
A statutory declaration saying what?
Saying that he, Mr. Cooke, had actually given her the $170,000 as part of some business agreement.
I see. So the Crown would allege this false document was created to try and explain away the $170,000, to make it look legitimate and keep it away from the restraining orders and potential confiscation.
Precisely the Crown allegation. A calculated move, they argued, to defeat the court orders and hide potential proceeds of crime. And Mr. Cooke apparently cooperated fully, gave police a statement detailing all this. Interestingly, he wasn't charged himself.
And then came the phone taps, the intercepted conversations. That sounds like critical evidence.
It really was pivotal for the Crown's case on these new charges. Investigators had intercepted calls and messages between Mr. Cooke and Mrs. Moukhallaletti in late August and early September 2016.
What did these intercepts allegedly reveal?
The Crown argued they showed the two of them actively trying to coordinate their stories about where that $170,000 came from to make sure they were consistent if questioned by authorities.
Like getting their story straight.
Exactly. The court material quotes bits like them discussing needing to make sure it matches up, otherwise they're gonna, and how it would be better if we are on the same page. They apparently talked about involving lawyers and accountants, asked each other if the authorities had called yet, and there were discussions about the money itself. Things like the majority of money out, Ms. Moukhallaletti allegedly whispering, "Can you just keep it somewhere for me?" And talk about breaking down the numbers, calculating interest. It painted a picture, from the Crown's view, of active collusion.
That does sound like strong evidence, suggesting they knew the money's origin was problematic and were trying to disguise it. And doing this, allegedly, while she's already on bail for the first set of justice-related offenses.
That was the core of the Crown case. They also pointed to some unusual meetings that allegedly took place. A solicitor supposedly meeting Mr. Cooke in a public park. Then Ms. Moukhallaletti meeting Mr. Cooke several times, including at her home, apparently to discuss how to break down or account for that $170,000 sum.
So all this new evidence, the statement from Cooke, the intercepts, this leads to her being arrested again.
Yes. Based on these fresh allegations and the evidence, particularly those intercepts, Kristen Moukhallaletti was rearrested on the 14th of September 2016. And significantly, unlike the first time, she was refused bail and has remained in custody ever since that date.
Okay, so now she's locked up, facing 2 sets of serious charges. The second set, crucially, alleged to have happened while she was on bail for the first. Naturally, her lawyers would apply for bail again.
They did. But now the legal situation was completely different. That allegation of reoffending while on bail, it creates a much, much higher hurdle under the Bail Act.
Where did they make this new bail application?
The first attempt was in the Supreme Court of New South Wales.
Okay, the Supreme Court. And which judge heard that application?
The application came before Justice Bellew.
And what was Justice Bellew's decision?
On the 11th of November 2016, Justice Bellew refused bail.
Refused? That's a significant finding from a Supreme Court judge.
It certainly is. It signals an initial judicial assessment that, either the Crown case on these new serious matters looked pretty strong, or the risks involved in granting her bail again were just unacceptably high. Or, most likely, a combination of both. The record doesn't name her specific lawyers at that Supreme Court stage, but she would definitely have had legal representation.
So, refused bail by the Supreme Court, liberty denied. Where do you go from there? The fight escalated, didn't it?
It did. The next step, and really the main event we're focusing on, was taking the fight up another level. A release application directly to the New South Wales Court of Criminal Appeal, the CCA. That's the state's highest court for criminal matters.
And going to the CCA for bail isn't just asking them to look at it fresh, is it?
No, it's generally not a simple do-over. The defense team typically needs to persuade the CCA that the judge below, in this case Justice Bellew, made some kind of legal error in refusing bail, or perhaps that there are compelling new circumstances that weren't before the first judge. The stakes were incredibly high for Ms. Moukhallaletti.
Who were the judges sitting on the bench for this crucial CCA hearing?
It was heard by a panel of 3 very experienced appellate judges: Justice Gleeson, J.A., Justice Rothman, J., and Justice Button, J.
3 judges. And who were the lawyers?
Yeah.
Given the seriousness and complexity, I imagine both sides brought out their top advocates.
You imagine absolutely correctly. This was definitely not your run-of-the-mill bail application in terms of legal representation. Appearing for the applicant, Kristen Moukhallaletti, was Mr. G. Turnbull, SC.
SC, senior counsel. That signifies a top-tier barrister.
Exactly. One of the most experienced and respected advocates. He was instructed by the law firm Corn McDougal Legal.
And representing the Crown, the Director of Public Prosecutions.
The DPP also fielded a formidable opponent, Mr. M. Sink, SC, also senior counsel. He was instructed by the solicitor for public prosecutions.
Wow, 2 senior counsel arguing a bail application in the CCA. That tells you something, doesn't it?
It absolutely does. It signals just how significant and legally complex this case was considered to be by both sides. You have to remember, the Bail Act 2013 was still relatively new back then, maybe only a couple years old. So cases like this, testing its boundaries, especially these tricky provisions about reoffending on bail, they become really important test beds for clarifying the law.
Okay, so with these legal heavyweights facing off before 3 senior judges, what were the core legal battlegrounds? What were they actually arguing about?
The entire fight really hinged on key sections of that Bail Act 2013. The absolute central issue was something called the show cause requirement. This is in Section 16A, subsection 1.
Show cause. What does that mean in practice?
It means that because Mrs. Moukhallaletti was charged with serious indictable offenses, especially that heavy proceeds of crime charge, and the fact she was already on bail for other serious charges, the usual presumption in favor of bail was reversed. The onus flipped.
So instead of the prosecution having to prove she shouldn't get bail,
She had to prove she should. She had the burden of actively demonstrating to the court on the balance of probabilities why her detention was not justified. It's a significant hurdle. She starts behind the 8 ball, so to speak, with custody presumed appropriate unless she can show otherwise.
and was there anything specific in the act that made her situation even tougher?
Yes, absolutely. Compounding that difficulty was Section 16B, subsection 1, paragraph H, subparagraph I. That's quite specific, I know.
Okay.
But what that subsection does is specifically trigger the show cause requirement if the applicant is alleged to have committed a serious indictable offense while already on bail for another serious indictable offense. It fit her situation perfectly.
So the law singles out that exact scenario, reoffending on bail for serious matters.
It does, and it makes the task of showing cause even more demanding. Why? Because it represents an alleged fundamental breach of the court's initial trust. The court let you out once, and now you're accused of committing another serious crime. That requires a very strong justification for release.
Okay, so showing cause is hurdle number 1 and a very high one in her case. Even if her lawyers could convince the court she'd shown cause, was that the end of it?
No, not necessarily. There's a second major hurdle, the unacceptable risk assessment, which is under Section 18 of the Act.
Unacceptable risk. What risks are we talking about?
The Act lists 4 specific risks. The court must refuse bail, even if cause is shown, if it believes there's an unacceptable risk that the person, if released, would 1. Fail to turn up for court, 2. Commit another serious offense, 3. Endanger the safety of victims, individuals, or the community, or 4. Interfere with witnesses or evidence.
And those new allegations involving Mr. Cooke and the $170,000, they sound directly relevant to those risks, especially interfering with witnesses or committing further offenses.
Highly relevant. The nature of those new allegations, allegedly fabricating evidence, dealing with proceeds of crime involving potential coercion of a witness, Mr. Cooke, pointed squarely towards risks like committing further offenses against the administration of justice or interfering with Mr. Cooke himself.
And then there's Section 22 about bail conditions. Where does that fit?
That only really comes into play if the court gets past the first 2 hurdles. If they think cause has been shown, i.e., they think the risks might be manageable, then they look at Section 22. They assess whether imposing specific conditions like reporting to police, curfews, sureties, non-contact orders could sufficiently mitigate those unacceptable risks down to an acceptable level.
Okay, so a multi-layered test, show cause, then assess unacceptable risk, and only then consider conditions. Mr. Turnbull, SC, for Mrs. Moukhallaletti, had a massive task then. What were the arguments he put forward to try and convince the CCA she had shown cause why her detention wasn't justified?
He focused heavily on the human impact, particularly the really grievous effect her continued detention was having on her 3 young children. This was presented as a primary factor.
Right. Tell us more about the children's situation. That sounds like a powerful emotional argument.
It was. There were 3 kids aged 14, 7, and 4 at the time. Mr. Turnbull emphasized the severe disadvantage and distress they were facing with both parents now incarcerated. The situation for the 14-year-old son was highlighted as particularly concerning.
Why was that?
He reportedly had serious pre-existing behavioral issues, ADHD, was on medication, seeing psychologists, described in the material as being aggressive and difficult to manage. The caregiver apparently felt the recent events had brought out the worst in him. There was even a concern raised that he might refuse to attend a planned residential school placement, which was seen as crucial for him if his mother remained locked up.
That's tough. And the younger ones?
The 7-year-old was said to be handling it reasonably well, all things considered, but the youngest, the 4-year-old daughter, was apparently suffering significantly, crying bitterly every night, missing her mother terribly. It paints a picture of real family distress.
And who was actually looking after them? Were there challenges there too?
Yes, that was part of the submission. The primary caregivers were relatives and friends facing their own serious health challenges. The husband's brother, Mr. Paul Moukhallaletti, suffered from Parkinson's disease, had tremors, wasn't confident making school runs, appointments, etc., very difficult.
Okay.
And the other main helper was a friend and neighbor, Mrs. Beverly Donnelly, who herself suffered from severe chronic degenerative multiple sclerosis, affecting her both physically and mentally. So, while counsel acknowledged the care was there, the children weren't totally abandoned, or bereft was the word used. It was argued to be far from ideal and under significant strain.
So the impact on children was argument number one. What else did the defense put forward to try and show cause?
They argued she faced losing her job. She'd worked for the NSW Department of Family and Community Services for a very long time, since February 1999, over 17 years. She was currently on leave without pay, and it was submitted her income was needed for the family.
Her employment record and ties to the community.
Yes, her prior good character, specifically her lack of any criminal record before these charges, was emphasized, along with her strong community ties, mainly through her children and long-term residents.
Thank you, the points.
Finally, the issue of delay was raised. It was submitted there would likely be significant delays before the new, serious charges, the strictly indictable proceeds of crime matter, and probably the associated fabrication charge could be finalized, likely in the district court. Although it was noted the first set of charges were scheduled for a summary hearing relatively soon, in early 2017.
Okay, so impact on children, potential job loss, prior good character, community ties, and court delays. And presumably they proposed strict conditions if the court was persuaded.
Oh yes, very strict conditions were put on the table. Things like having to live at home with the children, reporting to the police every single day, a complete ban on any contact, direct or indirect, with any Crown witnesses, obviously, including Mr. Cooke. Also, not allowed within 1 kilometer of any airport or departure point, a standard good behavior bond, and importantly, a substantial financial guarantee, a $35,000 surety, offered by 3 separate people willing to pledge the money.
So a comprehensive set of arguments focusing on her personal circumstances and proposing tight controls. How did the CCA judges respond? How did the scales ultimately tip?
Well, the 3 judges, Gleason J.A., Rothman J., and Button J., clearly deliberated very carefully. They weighed all those submissions from Mr. Turnbull, SC, against the Crown's arguments, the evidence, and importantly, Justice Bellew's original decision to refuse bail in the Supreme Court. Justice Button J. ended up delivering the main judgment, the reasons for the court's decision, and Justices Gleason and Rothman both agreed with him completely.
And the final outcome was?
The release application was refused, bail denied again. The CCA actually made its formal orders quite quickly, on the 16th of November 2016, just a few days after the hearing, but then provided their detailed written reasons for that decision a month later, on the 16th of December 2016. That's pretty standard practice when the court wants to give thorough reasoning for a significant judgment.
Bail refused by the CCA. So what were Justice Button's key reasons? Why did the court find that Mrs. Moukhallaletti had failed to meet that high show cause bar? Failed to convince them her detention wasn't justified?
Justice Button systematically addressed the points raised by the defense. Crucially, he focused first on the strength of the Crown case regarding that second set of allegations, the ones allegedly committed while she was on bail.
The fabrication and proceeds of crime charges involving Cooke.
Exactly. He found the Crown case on these charges appeared to be strong, and he specifically pointed to those intercepted conversations as being highly significant. He felt they provided strong support for the Crown's theory of calculated reoffending while she was out on bail.
So, even though the defense might later attack Mr. Cooke's credibility at a trial.
Right. Acknowledging that defense point, Justice Button nonetheless viewed the content of the intercepts themselves as compelling evidence suggestive of her direct involvement in coordinating false stories and dealing with the $170,000. That was a major factor against her.
Okay, strong Crown case on the new matters. What else?
Secondly, the seriousness of the charges themselves. Justice Button didn't downplay any of them. He viewed both sets of charges, the original fabrication allegations and the new ones, as representing serious attacks on the proper administration of justice. And he explicitly stated that, for the purpose of considering bail, if she were ultimately convicted of these offenses, a sentence involving full-time imprisonment could reasonably be expected.
The likely penalty, if convicted, always weighs heavily in bail decisions, doesn't it?
It certainly does. Thirdly, he considered the context. He noted the background allegations about her husband having access to potentially vast sums of money and assets, and the fact that the new charges and those intercepted calls involved a very substantial sum, that $170,000.
How did that context influence the decision?
It raised concerns for the court about the resources that might potentially be available to her, perhaps to flee or disappear if granted bail. That concern, Justice Button felt, was significantly exacerbated by the strong allegation that she had already demonstrated a willingness to disregard court processes by allegedly reoffending while on bail.
Okay, that makes sense.
Okay.
But what about the children? That seemed like a very strong point for the defense. How did the court address the clear hardship they were facing?
The court didn't dismiss it lightly. Justice Button explicitly acknowledged that the children were suffering distress and disadvantage due to her incarceration. He also acknowledged the caregiver's own health challenges and the particular difficulties with the eldest son. But ultimately, he found that the circumstances of the children, while undoubtedly difficult, were not compelling enough in this specific context. They had to be weighed against that strong Crown case, alleging she committed serious public justice offenses while already on bail. He used the phrase that the children, while suffering, were not bereft. They did have care arrangements in place, even if those arrangements were imperfect.
So hardship to family is a relevant factor, but it wasn't enough here to overcome the other concerns, especially the alleged bail breach.
Precisely. It highlights that difficult balance. While family hardship is always considered, its weight can be diminished when assessed against very serious allegations, particularly those involving a breach of the court's trust through reoffending on bail. It wasn't enough on its own to satisfy the show cause requirement here.
That must have been a really tough finding for the family to hear. What about the argument about her potentially losing her job?
On that point, Justice Button found there wasn't actually any concrete evidence put before the court confirming she would lose her job if bail continued to be refused. He noted she was already on leave without pay and hadn't apparently requested an extension or provided confirmation from her employer. Given her very long period of employment over 17 years, he felt it would be somewhat surprising if her job was just automatically terminated without further process. So that argument didn't carry much weight in the end.
And her prior good character, her lack of a criminal record before all this.
Again, acknowledged by the court. Justice Button accepted she had no prior convictions, but he had to weigh that against the strength of the current allegations, especially the allegation that she had fundamentally breached the court's trust by reoffending while on bail. He essentially said that while it's always regrettable for someone with a clean record to be refused bail, that factor alone couldn't overcome the specific serious circumstances presented in this case. It wasn't sufficient by itself to show cause.
What about the potential for court delays? Did that sway the court?
The court acknowledged that delays in the justice system are, unfortunately, a reality. However, Justice Button found nothing in the material presented to suggest that the likely delay in resolving the second set of offenses in the district court would be exceptional or unduly lengthy compared to other similar cases. It wasn't seen as a delay so extreme that it would, on its own, justify granting bail in the face of the other concerns. He also noted the first set of charges were listed relatively soon.
So putting it all together, the strong Crown case on the new charges, the seriousness of all the offenses, the context of alleged resources, the assessment of the children's situation, job loss, prior character, and delay, the court concluded she hadn't met the high bar.
That's right. Justice Button concluded that, even when considering all those factors raised by the defense together, they did not cumulatively reach the high threshold required by Section 16A to show cause why her detention was not justified. The alleged reoffending while on bail was clearly a critical, perhaps decisive factor weighing against her.
And didn't Justice Button add something else? A sort of backup reason for refusal.
Yes, he did. He made an ancillary finding. He said that even if he was wrong in his conclusion about the show cause test, hypothetically, even if she had shown cause, he would have still refused bail anyway.
Why? On what grounds?
On the grounds of unacceptable risk under Section 18. He stated he held an affirmative belief, meaning he was actively satisfied that if she were released, there would be an unacceptable risk that she would commit a serious offense against public justice. Specifically, he was concerned about the risk of her interfering with the key prosecution witness, Mr. Ryan Cooke.
Because the very nature of the alleged new crime involved trying to influence or fabricate evidence relating to Mr. Cooke.
Exactly. The alleged new offense itself involved Mr. Cooke and attempts to, allegedly, manipulate evidence concerning him and the $170,000. So releasing her back into the community seemed, in the court's view, to create the very real and unacceptable risk that she might try to interfere with him further as a witness. It directly linked the alleged conduct to a specific future risk.
That makes complete sense. The facts alleged seem to predict the potential risk. Okay, so the final outcome for Ms. Moukhallaletti herself was clear. Bail refused. She remained in custody, awaiting the resolution of both sets of charges. But looking beyond her individual case, you said this Moukhallaletti judgment had broader significance. How did it actually change or clarify Australian legal practice?
It really became a landmark decision, especially within New South Wales, because it provided much needed authoritative clarity from the Court of Criminal Appeal on how to interpret and apply those really difficult provisions in the Bail Act 2013.
Particularly the show cause parts.
Yes, especially the general show cause requirement in Section 16A, but most pointedly, that very specific provision in Section 16B1, the one dealing directly with alleged reoffending while on bail for another serious indictable offense. That scenario is one of the toughest for courts to grapple with, and Moukhallaletti gave clear guidance.
And it also helped clarify the unacceptable risk assessment in those situations.
It did. It showed how the specific circumstances of the alleged reoffending could directly inform the assessment of future risk under Section 18, particularly the risk of further offending or witness interference.
So it essentially gave lawyers and judges a clearer roadmap for handling these specific high-risk, high-stakes bail applications.
Precisely. It offered really invaluable practical guidance. For defense lawyers, it starkly illustrated the incredibly high evidentiary burden they face in these show cause situations involving alleged reoffending on bail. It showed that relying solely on factors like hardship to children or prior good character, while relevant, might often not be enough to overcome a strong Crown case alleging a breach of bail trust.
And for prosecutors.
It strengthened their hand, providing clear precedent to rely on when arguing against bail in these specific circumstances.
And for judges making these tough calls every day.
It provided authoritative guidance from the state's highest criminal court, promoting consistency in how these complex and often quite contentious provisions of the Bail Act were applied across the board. Reducing inconsistency is a key aim of appellate judgments.
And you mentioned the Bail Act 2013 was still relatively new then, so cases like this were crucial in building up the body of law around it.
Absolutely vital. When new legislation is introduced, especially something as complex and frequently used as a Bail Act, there are always ambiguities or areas needing clarification. Appellate court decisions like Moukhallaletti are essential for interpreting the legislative text, applying it to real-world facts, and establishing precedents that guide all future decisions. It played a really significant role in shaping the understanding and application of the Act, particularly in this very difficult area of alleged breaches of bail.
Okay, so let's just recap our deep dive into Moukhallaletti v. Director of Public Prosecutions, NSW. We followed a really dramatic procedural path, haven't we? From those initial charges and that crucial first grant of bail, that grant of trust, through to the new serious allegations allegedly committed while on that bail.
Leading to her rearrest, refusal of bail in the Supreme Court by Justice Bellew, and then that high-stakes showdown in the Court of Criminal Appeal before Justices Gleeson, Rothman, and Button, argued by senior counsel Mr. Turnbull SC and Mr. Sink SC.
And the key takeaway.
Yeah.
Why is Moukhallaletti considered such a pivotal case?
I think the main takeaway is that it provided absolutely essential clarity on a particularly thorny question under the Bail Act 2013. How should courts assess bail when someone stands accused of committing more serious crimes while they were already entrusted with freedom on bail for other serious crimes? It powerfully illustrated the very heavy burden an applicant faces under that show cause test in those specific circumstances. And it clarified how the court weighs factors like genuine family hardship against the perceived strength of the Crown case, the seriousness of the alleged breach of trust, and the overall public interest in maintaining the integrity of the justice system.
It really leaves you with something fundamental to think about, doesn't it? This case throws into such sharp relief just how much trust the legal system actually places in a person when it grants them bail. And conversely, just how incredibly difficult it becomes to demonstrate that continued liberty is justified once that trust is alleged to have been broken, especially through committing serious new offenses. It really makes you pause and wonder, in the face of those kinds of serious new allegations committed while on bail, what does it truly take to satisfy a court that detention is not justified?